Welcome to the legal podcast containing legal questions and answers in layman's language. Today's topic is medical malpractice. Hi, I'm John Deary, and I am delighted that you're here with us. And I am very pleased to welcome as our expert guest today, attorney Eliot Wolf, who is from the law firm of Wolf and Furman, and Eliot has focused considerable litigation with regard to individuals that have been injured as a result of a medical malpractice. So he's a very knowledgeable attorney in this field. And welcome, Eliot.
Thank you, John.
So how would you define medical malpractice in the eyes of a potential client?
Well, the legal definition is a departure from good and accepted standards of care. To put it into plain English, if you believe a doctor did something wrong, and that what they did wrong caused a significant injury or caused someone to lose a significant chance of a cure, then you should seek out medical malpractice legal help. So the standards of medical care, unfortunately, are not codified or written out. But there are things that we all know. So, for example, if you go to a doctor on a regular basis, and you follow that doctor's instructions and directions, and then all of a sudden, you or a loved one finds out that they have very advanced cancer, that's one reason to seek out a medical malpractice attorney. Because if you are doing everything you're supposed to be doing, you should be screened, you should be checked, you should be monitored. And an advanced condition generally should not occur in the absence of something being done wrong by a physician.
You mentioned a doctor. Obviously, in medical malpractice, you initially think about a doctor, but what are some of the other standard sort of defendants in medical malpractice?
Well, you could first of all, it could be almost any doctor. It could be a general physician, a pediatrician, obstetrician, gynecologist, any doctor that should be monitoring a patient for any type of physical condition, nurses. Some people who are treated in nursing homes can be the subject of malpractice litigation or nursing home litigation, because in that instance there are some laws which protect the most vulnerable in our society. So pretty much anybody who renders any sort of medical care or even ancillary care that is tangential to regular medical care can be subject to medical malpractice litigation.
You use the word a departure from accepted practice. I think that's important for you to clarify for our listeners.
Okay, well, let's compare it to a driver. The rules of the road, so to speak, are that if there is a red light, you stop. If somebody goes through the red light, they're negligent. Doctors have rules as well, standards, and those standards are called the standards of care. For instance, if a patient comes in and there are signs and symptoms that they might be diabetic, the doctor has a duty to take several types of blood tests. The simplest one would be blood sugar. But if they're monitoring someone, there's one that's much more exacting, which is called hemoglobin A1C. It's a different type of blood test. If a doctor has a patient who should be monitored for either diabetes or their hemoglobin A1C should be monitored, and the doctor doesn't monitor them and they end up with diabetes and go into a diabetic coma, that's the doctor's fault. That's because the doctor didn't follow accepted standards of care. That doctor went through the red light and harmed somebody.
When you are doing litigation, which is or wonderful ability of an attorney. How do you find the jury's ability to comprehend and understand the medicine, since the medicine is really at the heart of medical malpractice? How do you evaluate a jury's ability to understand the medicine and the causes of the injury?
Well, the biggest hurdle and responsibility of anyone who does litigation from a malpractice standpoint is to educate the jury. And you can educate the jury with pictures, with models, with very good experts who could explain to a jury why something is wrong and why and to make sense of it to a jury. So one of the most recent cases I tried is a case where a patient had what's called an ablation, had a procedure where a portion of tissue was actually buzzed out or killed, and it was supposed to be. But a side effect that's known to that is that tissue next to that could be damaged or injured. And in this case, that's what happened. Now, that can happen without malpractice, but what the doctors have a duty to do is to monitor the patient. And if this complication develops, to diagnose it and treat it promptly. And in this case, they didn't do that. So we had a big model which showed how close to the area they were working was the area that was injured. We had a blow-up that showed it. We showed it to them on the MRIs. We explained it to them. And then we showed them the medical records as to what the thought process of the doctors was and what it should have been. And we really made very simple arguments about medicine that some people would think is somewhat complex, so that the jury understood at the end of the case not only that the client had an ablation, but how it should have been monitored afterwards and why we believe there was malpractice in that it was improperly monitored and treated.
So I'm gathering from what you're saying is not only is the responsibility on the attorney to clarify and explain the medicine, and my question to you is, again, as I mentioned before, do you think that juries are able to absorb what is necessary in ultimately reaching a decision?
Well, I believe they are if they're presented with the medicine properly.
Okay.
And what a defendant does in those types of cases is tries to make the medicine much more complex and say, the doctor had to worry about this and about that, and to throw in all sorts of terms and different parts of the anatomy in order to make a jury think, wow, the doctors have so much to deal with, this is so difficult. So I believe that what a defendant does when they're somebody defending a doctor, what they try to do is they try to make the doctor into such an expert and so knowledgeable so that jurors who don't understand will tend to lean towards the physician who we are trying to prove committed something wrong. So if we do our task properly and teach the jury the medicine and show them logically why A, B, and C had to be done and how it wasn't done, then we should win the case for our client.
We're talking about medical malpractice here, and that's, I think it's fair to say, what a majority probably of your practice is. But I know you do trials in other areas, motor vehicle and slip and fall and so forth. So my question to you is, do you find a malpractice case to be more challenging than a non-malpractice case?
Absolutely. Most car accident cases or trip and fall cases, you're suing an individual saying that they drove improperly. They generally have insurance coverage. Nobody's reputation is at stake. Nobody feels like their professionalism is being attacked. When you sue a landowner, a building, a landlord, for somebody who tripped and fell on that property because they didn't maintain it correctly, again, generally there's an insurance company involved. When you're suing a physician or a hospital, if you get a verdict against them or even a settlement, that settlement is lodged against them and on their record. Whenever the doctor goes for hospital privileges somewhere else, also obviously for malpractice premiums as well, but it is much more hard fought and litigated because there's much more at stake from the physician's point of view and from the hospital's point of view as well.
There seem to be two necessary factors to present a medical malpractice case: deviation from accepted standards and deviation must have caused the injury that resulted. Is that really the guts of what we should be thinking about in a very simplistic way relative to malpractice cases?
Absolutely, those are the two steps. Something has to be proven to have been done wrong, and as a result of what was done wrong, one would have to prove that that caused significant injury or damage to the patient. For instance, there are a lot of times that I get calls about cases where there was a delay in diagnosing cancer. Now, if the cancer is a cancer that would ultimately kill a patient anyway, certain types of pancreatic cancer are the mortality rate from the cancer is over 99%. So if there's a delay in diagnosing that and initiating treatment, that might be a departure. But did that cause an injury? The person, once they're diagnosed with pancreatic cancer, chances are that their life expectancy is really curtailed. Chances are they're going to die from that cancer in a relatively short period of time. So the failure to timely diagnose it and treat it might not be a substantial factor in causing harm to the patient. So, along those lines, if somebody has metastatic cancer that's spread from an original source, and the metastatic cancer is not diagnosed promptly, that might not be a cause of significant harm to the patient, because most metastatic cancers have very poor prognoses or outcomes just by virtue of them having spread to a part of the body far from where they originally originated.
There are some general categories of examples of medical malpractice, and I'd be interested in your reaction to it, and I know you touched a little bit on it, but the first one would be misdiagnosis.
Misdiagnosis cases sometimes are the easiest cases to pursue. There are so many blatant examples and scary examples that I have seen over my career. You have cases where doctors order a test on a patient, and the test comes back and says, you should follow up and do this other test because this patient might have cancer. Or we found this in the patient, we recommend further treatment. And I don't know what the reasons really could be to justify it, but there are occasions where the doctors do not act upon those recommendations. And if they don't act on the recommendations, by the time a patient finds out about that, it could be a year later. It could be 2 years later. So I had a case where a woman was having a problem, went to a hospital, they took a chest x-ray, and then they sent her home from the emergency room. The chest x-ray came back, they found not a spot, but a big spot on her lung, which was spiculated. Now, a spiculated spot is kind of a spot which has tentacles coming out of it. When somebody finds a spiculated spot or tumor on an x-ray, that's an indication that there's a high likelihood of this being cancerous. Now, since it was just on one part of her lung, she could have been treated with either cutting out that area of the lung or cutting out one of the lobes of the lung, and she could have had a very long, happy life ahead of her. But nobody ever told her. She left the emergency room before that x-ray was read. When the x-ray was read, nobody did anything with that reading in order to contact the patient. 2 years later, she shows up at the same hospital. And when she shows up at the hospital, they take an x-ray and they ask her, how come you never got treatment for that spot on your lung? And she never knew she had that spot. Unfortunately, she wasn't the person to come to me with the case because she passed. And her daughter came to me. And then when we found out about this and we started a lawsuit, the first defense that they had was, you can't sue because it's 2.5 years after the original x-ray was taken. And therefore the statute of limitations is expired. And in that case, we tried something very novel. So instead of just suing for malpractice, which has a 2.5-year statute of limitations, we argued this is not malpractice, this is negligence. That anybody and everybody, you don't need a medical expert to tell you, if there's a spot on the lung, it should get investigated and possibly treated. And that is just negligence. I don't need an expert to tell a jury that if there's a spot on a lung that's seen on an x-ray, the patient should be informed about it and it should be investigated. And the judge agreed with us and extended the statute of limitations from 2.5 years to 3 years, which is what the negligence statute was. And we were able to proceed with the case and get that woman's family some justice.
Get around the statute of limitations issue.
Yeah.
Let me give you the second category, and that is failure to diagnose.
Failure to diagnose, again, people present with certain symptoms. And those symptoms have to be evaluated. So if somebody is spitting up blood, there's certain tests that should be done, a chest x-ray, blood tests, probably a CAT scan. If somebody is a long-term smoker, there are guidelines as to what tests that patient or that person should undergo. Nowadays, there's a low-dose CT study that should be done on anybody who's had more than 20 years of smoking cigarettes, of a pack a day. And if that test is not done, that's malpractice. That's a departure from the standards of care. Testing, doing colonoscopies or testing for colon cancer in patients over 50, doing mammographies on women over 40. There are certain tests that have to be done. And if they're not done and the patient develops the cancer that should have been screened for, that's a failure to diagnose that a doctor is liable for.
The third category is surgical procedures.
Now, surgical procedures are a little bit harder to prove malpractice because the only witnesses to the surgical procedure is the doctor and the medical staff who you want to sue. And they wrote up a report. Hey, this is what happened. So if they nick something, they nick an organ next to where they were working, they write down, hey, there were adhesions. There was a lot of scar tissue. I had to clean out the scar tissue, and in doing so, sorry, that's okay.
Sorry.
Okay. So when you sue a doctor for a surgical error, you have to overcome their operative report. And doctors do something that everybody knows what it's called. It's called CYA, cover your ass. So they will make sure that what's written in that operative report does not hang them out to dry, even if the reality is they cut an organ that they shouldn't have cut, they cut too much into an organ, or they made some other mistakes. So it's sometimes very difficult to prove those mistakes. And if you go through medical literature will justify making an incision or a laceration in an adjoining organ on almost any type of surgery. But there's some medical errors that cannot be covered up with an operative report. I have a case right now where a woman had diverticulosis, a problem with her intestines, where a portion of her intestine had to be removed. And the doctor, there's no argument that she needed that procedure. The doctor wrote up an operative report. Sounds like everything was done perfectly normally. After the procedure, she's having a lot of problems, a lot of pain. And they attribute that pain to the surgery. After they let her out of the hospital 5 days after the initial surgery, she comes back a day later to the emergency room, not only complaining of pain, but the staples to close her initial wound had opened up. They don't even do any investigation. They say, oh, she says she fell. They send her home. She comes back 2 days later. In the emergency room now, they order a CAT scan. And when they do the CAT scan, they find something was left inside of her. So they open her up, and they find that they left a 34 by 34 centimeter laparotomy pad. They left a towel inside this woman when they closed her up. No operative report's going to save that doctor. And unfortunately, the results of leaving that in this woman, her body reacted to it. She had terrible infections which made fistulas or tracts through which the infectious material had to get out of her system. She ended up suffering for 2 months, undergoing at least 9 procedures and passing away.
Let me give you a terminology that is important, I think, for our clients to understand. Informed consent.
Now, informed consent is a lovely idea, and unfortunately in New York it's a tough thing to prove, and I'll explain to you why. Informed consent stands for the very simple proposition that every patient should be given the information necessary to make the decision for themselves. Should I have this procedure? Are there other procedures that I can choose from? Which would I choose? And what are the complications and risks of the procedure? And what are the complications and risks if I don't have any procedure at all? That's the information that a physician has to give to a patient. In my experience, both as a medical malpractice attorney and as a patient, I find that's rarely properly and exhaustively done.
Does that informed consent issue become part of malpractice litigation?
It does to some extent. In New York, you cannot win a claim for lack of informed consent if a patient says, I wouldn't have had that procedure, because you have to prove one thing further, and that is, would a reasonable person have undergone that procedure if they were properly advised? So if there is a rare complication to a procedure, most doctors will say you do not have to explain to a patient that, you know, people can rarely die from this procedure, or people can rarely undergo this series of issues which could lead to death or lead to some other horrendous result. They only have to be told the more common complications. And that makes it a little more difficult to prove a lack of informed consent.
We are trying on these podcasts always to ask the question, because of its importance, statute of limitations.
Statute of limitations, in the most general sense for medical malpractice, is 2.5 years. That's 2.5 years, not from the last date of not from the date that the malpractice was performed, but the last date that the patient was continuously treated by the same physician for that condition. So if somebody has surgery on January 1st of 2021, and they continue with that doctor for another year and a half with complications from that procedure. Excuse me, all the way till the end of June of 2022. They have 2.5 years from the end of June of 2022. In cases where somebody dies, the wrongful death statute is only 2 years. And in cases where there's what's called a foreign body, if a foreign body is left in a patient, there is an extension of the statute of limitations till 1 year after the foreign body has been found. Also, there's also an extension of statute of limitations based on infancy. So if malpractice is committed on an infant, the infant has till they're 10 years old, or their family, to institute a lawsuit. Excuse me.
How often do you experience the situation where continuing treatment does in fact move that initial start of the statute of limitations?
It happens more often than not. Physicians, sometimes rightfully, sometimes wrongfully, tell patients, give it time. So if somebody has a complication from a surgery and they're told to give it time, generally they will. So I had a case where a patient of mine had a hernia surgery, and after the hernia, a client of mine had hernia surgery, and after the surgery they were in terrible, terrible pain. And they kept going back to the surgeon. And the surgeon believed that they would get better, or wanted the patient to believe they would get better. And that extended the statute of limitations by approximately a year. It turned out the reason the client was in such pain was because the surgeon had tied up a nerve during the surgery. So that nerve was being strangulated, and it was exquisitely painful. And the case, in essence, was not only that the nerve was strangulated in the original surgery, but that the surgeon dismissed the complaints of his patient. And when he had the opportunity to go in there and free up the nerve and basically save my client from a lifetime of pain, he took the position that he did nothing wrong. There was no reason for him to investigate further. So that even though my client ended up having that nerve freed up from being strangulated, and the subsequent surgeon found and documented stitches around that nerve, even though that was done, my client had a lifetime of pain because he had developed an intractable pain syndrome, a pain syndrome that wouldn't go away even after the nerve was freed up.
If you look back on your cases, do many of them require a notice of claim? And if so, what is that notice of claim?
Notice of claim is involved whenever you deal with a municipal entity, a municipal hospital. So the city hospitals all have to be served with a notice of claim, which gives the city an opportunity to question the client early on with a preliminary or 50H hearing. If you have a case against the federal government, and that is more common than one would think, not just the veterans hospitals, but there's some clinics and entities which are federally funded and are under if a lawsuit has to be brought, it's under the Federal Tort Claims Act. So that has a different notice that has to be done. That is not within 90 days, that's actually within 2 years. And you can't start the lawsuit until that's done and until it's not acted upon within a certain period of time as well.
Generally speaking, you make reference to the fact that all municipal hospitals, obviously supported by the city of New York, and then require a notice of claim. But I'm very interested in your evaluation over the years of the Health and Hospital Corporation, the city hospitals versus private hospitals. Do you have any general sense about those two?
I think that there are some superior city hospitals where one can get appropriate care. There are some city hospitals which are not as adept at providing proper services, and there is a similar dichotomy or a similar gradation of private hospitals as well. Some private institutions are fantastic. Some doctors at some small hospitals are great, and some doctors at some great hospitals are subpar. So it's very singular to who the doctor is, more so than what institution it is.
If an individual passes away as a result of a medical malpractice case, can their family, might be the other spouse, maybe children, can they bring a litigation for malpractice?
Absolutely. The first thing that has to be done, if the person died without a will, is to set up an estate and get letters of administration or letters of limited administration, which will basically designate a point person who is the one who will then be able to act on behalf of the estate, hire the attorney, and do everything else that's involved. As part of what my firm does is we set up estates for people who we believe might well have a viable claim of medical malpractice or wrongful death, and that's part of the services that's provided for those people when we accept the case for litigation.
If a client and the patient is undocumented and suffers a medical malpractice, does their status as an undocumented impact yay or nay with regard to being able to go forward with a medical malpractice case?
It has no effect whatsoever. In the past, a lot of defendants tried to intimate that they would make sure something would happen to such a person bringing a lawsuit. But not only can they bring a lawsuit, they can bring the lawsuit and sue for their lost earnings as well. And that was a development over the last couple of years, that if they're making good money, as long as they can prove it, they can't say, oh, I make $150,000 a year and have no documentary proof. But if they have documentary proof of their income, of their earnings, then they are able to make a claim for lost earnings, even though they are aliens without status, without legal status as citizens in this country. It used to be that people who didn't have legal status, it would be very difficult for them to maintain a claim for lost earnings, because there was the fear that they would be deported or they wouldn't be able to continue working. But that is no longer the status quo.
Again, given your vast amount of experience in the medical malpractice field, what recommendations would you have to a client who thinks they may have medical malpractice? And I know that from our own experience, you have an awful lot of people that think there is a malpractice, but in effect, probably is not. But be that as it may, what is your recommendation to people considering malpractice?
You know, first and foremost, if you really believe something was done wrong, think about what the effect of that was. If somebody loses a loved one, if somebody loses a limb, if somebody ends up being unable to work for an extended period of time, if there's a big injury, that's step one. Because before anybody wants to spend the money necessary to investigate a case, they have to know that there's an economic reward at the end of that case. So it's going backwards. Is there a significant injury? There's a significant injury, that's step one. Next step is, what do you think was done wrong? Do you know that the person who suffered this injury, if it's not the person who's bringing the lawsuit, are they somebody who follows doctor's orders? Are they somebody who's a generally responsible person? Because one of the defenses in a lot of malpractice cases is that the patient didn't follow directions, that the patient was non-compliant, that the patient in some way contributed to the bad outcome. So you want to be able to know that you can address that. And then you want to get the medical records. Getting the medical records together A lot of people can get their medical records through their own patient portals, or they can speak to their doctors. They can speak to their healthcare providers. Sorry. They can speak to their healthcare providers and get their records. Get your records before you come to see the attorney. Those records will help the attorney make an assessment. Is this something that I want to go through if there's going to be a long hospital record? I've gone through 15,000 pages of hospital records on potential cases where I believe there's a potential. That takes more hours than I'd like to tell you, but I'm willing to make that investment if I have a good faith basis to believe there's a case. And the other thing is, if a loved one, or if it's you, if you had interactions with a physician where you think they're covering up, if you have an experience in a hospital, there's a hospital ombudsperson, there's a patient relations person, there are people from the hospital management who you can talk to. You can get answers from them and listen to those answers. And if they don't pass the smell test, then you talk to an attorney.
As I mentioned at the outset, you've got such a vast amount of experience in the malpractice area, and thanks for conveying so much of that today. Appreciate it greatly. Thank you, Eliot.
Always a pleasure, John.
Let me say also that each month there will be 2 podcasts. One will begin at the first day of the month and run to the 14th, and then the second one will run on the 15th to the end of the month. And I hope that you will, I'm sure you enjoyed today, and I think that you will enjoy many of our other future podcasts. So thank you very much for your time. Again, I'm John Deary, and most grateful for you. So long now.